Okay, so well, ready to go. Welcome. I'm Judge Andrea Maisley. I want to thank you for attending the first of 4 programs on the commercial division in the New York State Supreme Court. Today's program is on motions, but before we get to that, I'd like to can everyone turn off their microphones? Thank you so much. I'd like to tell you a little bit about the commercial division, where it is my pleasure to go to work every day, and I can't wait to get to work. So, as I said, I'm Andrea Maisley. I'm one of the judges, one of the 27 judges in the state of New York who has the privilege to work in the commercial division. I'm an elected judge where we have 8 commercial division judges. We have dockets that are between 200 and 400 cases each, which are entirely commercial. New York differs from federal courts and, where judges handle criminal and civil matters. In New York, our judges specialize in either criminal or civil. Within civil, we have matrimonial judges, guardianship judges, medical malpractice judges, cases against the city, and many judges who do trials every day and hear all types of. So while the New York State Supreme Court has been hearing cases since 1691, the commercial division was an innovation in the 1990s. And since then, many other jurisdictions have followed us and established business courts in other states and countries. So when we're talking about commercial here, we're talking about contract cases, lots of contract cases. In fact, in an academic study, older study, but it found that forum selection clauses in publicly traded corporations, 46% of them use New York law and New York forum selection clauses. Each court has a different jurisdictional amount. In our court in New York County, it's $500,000. In addition to all the contract cases, we have fiduciary duty with 1933 Securities Act cases, we have RMBS and CMBS cases, business divorces, corporate governance issues, licensing disputes, arbitration related matters, and attorney general enforcement actions, legal malpractice, insurance disputes. We have our own rules, commercial division rules. Many of them are model rules and our own individual rules. We have our own body of law that's captured in 11 volumes of commercial litigation in New York, 5th edition, edited by Bob Haig. And just a tip, when you're doing research in the commercial division, you might want to look at just sort of a little background to that, to those 11 volumes. For more information about the commercial division, I suggest that you visit the Advisory Council's video on the New York Court's website, nycourts.gov. We've organized these 4 programs to let you know about the commercial division. But you should also know we hire law clerks. And in fact, here in the commercial division in New York County, we hire 3 law clerks. Each judge has 3 law clerks, and they come and go at various times. So please visit, if that's something you're interested in, please visit the court's website, nycourts.gov, to the commercial division page. And you'll find each judge has a page, and we each have our own instructions on how to apply. We also have interns, college interns, high school interns, and of course, law students. So again, go to our web pages and you'll find out what the procedures are to apply. And there's also the court's website, nycourts.gov careers, which talks about the different jobs. So with that, I am going to turn the program over to my colleague, Honorable Jennifer Schecter, and Bob Giuffra from Sullivan and Cromwell. And I wish everyone a successful summer and enjoy your internships. So Bob, Judge Schecter, I turn it over to you.
Thank you.
Well, it's really great to be here with everyone, and I really wanted to welcome the summer associates. I gather we have law students and lawyers from almost 200 firms around the country watching this presentation, which says a lot about the way modern technology works. My name is Bob Giuffra. I'm the co-chair of Sullivan and Cromwell, And I can remember not too long ago when I was a summer associate and an associate, and I would have wished we could have done something like this. I think the technology didn't exist back then. And so the plan today is that Judge Schecter, who is a very respected judge on the commercial division, and I will sort of have a little bit of a Q&A with the assistance of these slides, sort of take you through some of the basics of motion practice in the New York commercial division. And I think, give you sort of a sense sort of the practical, some do's and don'ts of lawyering that maybe you wouldn't get. I went to Yale Law School, and we certainly didn't learn much practical law at Yale Law School that, hopefully we can get that to you. Judge Schecter, maybe you want to say a few things at the beginning.
Yeah, it's great to see everyone. I mean, when I started as an associate, my cases were in the commercial division, which was very new at the time. And in fact, my first case was in this very courtroom. So, it's exciting to sit in the commercial division. I feel like I've come full circle. And, I'm also excited for all of you starting your careers to give you useful pointers that hopefully will guide you as you progress.
So why don't we start with sort of something that maybe a lot of people don't even realize. When I became a lawyer, my father was a trial lawyer, and I watched a lot of Perry Mason when I was growing up, and you always think about, well, going to trial. And only 2% of cases go to trial. Most cases get resolved through motions or through settlements. And that's what we'll be talking about today. And we'll be covering motions for temporary restraining orders and preliminary injunctions, a way to stop the case and maintain the status quo at the beginning, motions to dismiss cases at the outset, discovery motions, summary judgment motions, and then settlement. And then at a subsequent presentation, you'll hear about trial practice. So here's some statistics. Now, the commercial division judges are incredibly busy. And this gives you just in the New York County, which is where Judge Schecter sits, they had over 4,000 motions filed in just 2022, and they decided more than 4,200 of those motions. And there were only, Justice Schecter, how many judges do you have on your court?
We have 8.
And so think about that. That's 500 motions per judge on average each year. That's a lot of motions, and some of those motions are decided in decisions that can be pretty lengthy, I would imagine.
Yeah, many of them raise very complicated issues that are critical in terms of the trajectory of the case. And I would say about 95% of our time is spent on motions. And the reason they're so important is that sometimes a decision has a tremendous impact on settlement. Often we'll see cases that have 30 claims in a complaint, and I'll tell you more about how I feel about that as we go on. But through motion practice, or sometimes even through conferences, we can whittle it down to which claims really are the viable ones and what types of damages are truly available in the case. And once that gets resolved, it puts the case into a posture for better settlement very often. So these motions are significant to disposition of the case.
And Justice Schecter, what does it mean when you have your docket is probably how many cases do you have typically?
It ranges usually about the 200 active case range. But that doesn't account for the ones that I've disposed of earlier in the year, but the average is probably a little over 200.
And the fact that you have so many cases sort of means that when you're a party before you, it's really important for the lawyers to recognize that you're running a very busy courtroom and to focus on the important issues that are in the case and really get the issues targeted and focused, and not assume that the judge, who's very busy, knows all the details of the case. Isn't that right?
Absolutely. There's no way we can keep track of 200 cases. When your case is on, we're very focused on it. But it's how you present the case that makes all the difference. You want to get our attention. You want to be concise and clear. You don't want to use a lot of legalese because, again, you want to get our attention. So keep it simple, keep it straightforward. Tell us why your issue is important, and you'll be successful.
Now, we'll talk today about litigation strategy. We'll talk about TROs and preliminary injunctions, motions to dismiss, discovery motions, motions for summary judgments, and appeals. A little bit about litigation strategy, which is something that I think is really important. You know, at the beginning of a case, it's really important to sort of figure out what type of a case it really is. Sometimes you have a case where, you know, you should win, a bad lawyer should win, anyone should win, and it's just about getting to victory. And then you have a case where your client may have done something really dumb or stupid or wrong, and you probably want to try to settle that case at the beginning. And then you have those cases sort of in the middle of what I call the litigation continuum, and figuring out, well, if it's going to be a case that's going to be hard fought and litigated, what's the best strategy for resolving the case? And so at the beginning, it's really important that lawyers understand the facts and the law that govern their case. And you want to understand who the key players are. If it's a commercial case, you want to understand what are the key transactions and events. You want to read the contracts, study the documents really carefully. You want to understand, well, why are these parties fighting with one another? You know, what is the business deal here that's gone wrong, and how maybe if it's possible to settle it, can we get everybody together and try to resolve the case quickly? Because I've always thought it was important to try to not so much have the fun of lawyering, but really try to solve problems. That's what lawyers do. We're supposed to solve problems. And if there's a way at the beginning, you can figure out, why do these two sides get to where they are, where they're basically pointing the guns at each other. Maybe there's a way that peace can be found at the beginning, because if you can resolve a case at the beginning, you'll save your clients a lot of money and you'll get what they want, you know, right away.
Yeah, litigation is costly. And, you know, if you know your client's objectives, I think it's very important. From a judge's perspective, we try to settle cases or have them settled sooner rather than later. But parties aren't always able to do it at the outset. Sometimes they're missing information and they need to exchange documents. Sometimes they may have crazy ideas about the value of the case. So that's what I was saying, where emotion really helps. But if you know your client's objectives too, it really helps in terms of resolution without expensive motion practice, because sometimes the parties' interests diverge in terms of their different objectives, and you can give and take and find a good meeting point.
Often people have unrealistic views of their cases, and one of the things that emotion can do is it can really confirm for one side or the other who's got the better of it. If it's a contract case, for example, whose reading of the contract is right, and then that may force a quick resolution. Now, let's talk a little bit about the jurisdictional rules. In the commercial division in New York, the jurisdictional threshold is $500,000 for most cases, and you've got to show that the amount that's in dispute is $500,000. And in your court, Judge Schecter, you see a lot of contract cases, breach of fiduciary duty cases, some fraud cases, misrepresentation cases, business tort cases, such as an unfair competition case, and then cases about the sale of assets, corporate restructuring, employment contracts, transactions that are sometimes governed by the UCC, and then other sometimes transactions involving banks. I mean, what would you say to someone who's sort of trying to figure out, does my case belong in the commercial division?
So keep in mind, for cases where there's a monetary threshold, the monetary threshold is exclusive of things like punitive damages and counsel fees. So that's often a mistake that I see. People think that they can get their case into the commercial division because they're asking for exorbitant punitive damages. That's not taken into account in the monetary threshold. So keep that in mind. But traditionally, most of our disputes are in the millions and billions of dollars range, and they do have the threshold satisfied. We see shareholder derivative suits, lots of different types of business transactional cases.
I think it's fair to say that the cases that come to your courts are the ones that would be in the TV show Succession.
Haven't watched. I'm a big TV watcher.
my kids all love Succession, so I tell them, they always ask me, what do you do? And I said, it's a little bit like what's going on in Succession. So shareholder derivative actions, that's where a lawsuit is brought by a shareholder, often against the executives and board of the company, claiming that they mishandled some aspect of the company or breached their fiduciary duties. Sometimes you have a commercial class action. And then you have these dissolutions of corporations, partnerships, and joint ventures. Let's talk a little bit about sort of figuring out, well, how do you know? One of the things you want to do at the beginning of a case is make sure you've read the rules. And in the commercial division, you have something called the CPLR, Civil Practice Law and Rules. The commercial division has its own rules, and then individual judges have their own rules. But one of the big issues is, well, does the case belong in the commercial division or in some other court in New York State? And that decision needs to be made upfront quickly. Is that right, Judge Schecter?
It does. You know, we have administrative personnel dedicated to looking at the RJI, the request for judicial intervention. That's the document that asks for assignment to the commercial division, and they usually check screen cases. So by the time they've screened them and they overall do a great job, there are only a few occasions where something may fall through the cracks where the judges believe this doesn't belong in the commercial division.
Now, the judges in the commercial division have been selected for their expertise in commercial matters. And the commercial division is a court that's really been set up and really has been a great focus on providing for the efficient resolution of legal disputes. And there are rules governing discovery and making sure that discovery requests are proportional. There's an option for accelerated adjudication. There are some limits on depositions. Trials are, when they do occur, are done, quickly. There's a real focus on trying to resolve the disputes. And there's actually a separate docket for large complex cases. And oftentimes, as someone who's litigated around the country, the big places where these big succession-like disputes are litigated are in the commercial division in New York, sometimes down in Delaware in the Chancery Court, sometimes in the Southern District of New York in federal court. And sometimes these matters just get arbitrated. From your perspective, Your Honor, what are some of the benefits of litigating in the New York commercial division?
It's the fact that this is what we do exclusively, and we have excellent clerks trained to work with us to manage cases well. It's the case management. And you mentioned earlier things that you should look at straight away. And this is very important for motions, and the whole case is the judge's individual rules. Look at the commercial division website. Once you get assigned to a judge, make yourself very familiar with those rules. They're searchable, so you can put in keywords. For example, if you have an order to show cause, we have specific procedures that we require you to follow. So looking at those rules will give you, a leg up in terms of how to proceed with the case. You'd be surprised at how many people don't pay attention to the rules. And this is something special. I mean, judges all over the state have individual rules, but more so in the commercial division, we're careful to lay out a framework for you to follow to get the most efficient disposition for your case.
New York has always been the center of finance in the United States and really the center of commercial disputes. And one of the reasons why practicing law in New York City makes so much sense is because, as was mentioned before, most contracts are governed by New York law. We have really great judges in our New York courts. And that's why a lot of the big disputes find their way to New York courts. In addition, the setting up of the commercial division by former Chief Judge Kaye, probably 20 or 30 years ago, and then the subsequent chief judges after that have really focused on trying to have our commercial division be the best place in the United States for the resolution of these big disputes. And having judges like Justice Schecter, who really focus on these cases day after day, gives the expertise that's needed to make sure we can resolve those disputes in the best way. Now, one of the issues that often comes up in a case is, does it belong in the commercial division? Should it be taken out? And a justice of the commercial division has the ability to try to move the case and say, well, it really doesn't belong here. A party can make a request to do that, but probably the more likely scenario that comes up is that the defendant can try to remove the case to federal court. And sometimes the defendants want to do that. They prefer being in federal court. Maybe there's a situation where the case involves a federal question, or there's diversity between the parties. So one party may be located in New York and another one may be in California. And the defendant may decide, well, I'm from California. I really don't want to be hauled into a New York court. So they want to get into federal court. But in order to remove the case, the federal court must have subject matter jurisdiction. And one of the reasons why sometimes if a case involves federal law issues, parties will try to remove it as some sense that, well, a federal court judge deals with federal court issues all the time. And then there are some differences with respect to the size of juries in New York courts versus federal courts, where a civil jury in New York court tends to be smaller. It's usually 6 with 5 needed for a verdict, whereas in federal court, you need unanimity and the jury can be between 6 and 12. I mean, Justice Schecter, any thoughts about, removing cases from state court into federal court when people try to do it?
My guess is that about 75% of the cases that people remove, that defendants remove, come back to us. And really, because it's based, usually they are trying to argue diversity based on incorporation and it comes right back to us. I have to believe that very often it is a delay mechanism.
And it isn't so good when you make a frivolous or a bad removal motion, and then you come right back to the judge where you were before, because judges don't like it when people are perceived as playing games. So you really have to make sure you have a solid basis for removing a case when you do so. Let's talk about some efficiencies in terms of resolving cases. There's a procedure, Your Honor, in the commercial division for accelerated adjudication. Could you tell us a little bit about that?
Sure. Parties can either put in a contract or agree in writing to forego certain case steps in a case, like extensive discovery. There's very limited discovery when you agree to accelerated procedure. You give up your right to a jury. A key facet in New York litigation is that you have the right, unlike in federal court, to go take certain issues up on appeal in the middle of a case. And that can really extend the duration of litigation. So by agreeing to this procedure, you forego certain rights, but you get super fast tracked in terms of a result. I will tell you that I have not once in all my years in the commercial division seen anyone take advantage of accelerated adjudication. And I think it's because people are nervous about what they're giving up in terms of putting that in a contract before they actually have a dispute. They're the ones always worried, well, maybe I'll need more discovery and maybe I'll want that interlocutory appeal. So it hasn't been, I haven't seen it invoked. It has happened, but not with me.
Let's talk a little bit about legal research. It's really important at the start, and we have, obviously with AI, everyone thinks that that'll be done by computer, but it's really important to understand the law that governs your case at the beginning and sort of understand, where the rules of the road are, and understand what are the elements that need to be shown and pled, and also where the disputes are going to be, and try to figure out, well, where does our case fit with other similar cases, and sort of roadmap it all out. So that's something that I think is just critical to do at the beginning of a case. And then obviously it's really important to do that factual development review up front. Your Honor, what do you think about, in terms of when a case comes into you, do you do any sort of legal research initially, or do you kind of wait for the parties to start briefing things up front?
Usually I wait for the parties because my initial introduction to the case very often is through a motion. So I have papers in front of me. There are times when my brilliant clerks can foresee that certain motions maybe should be made early on in the case and may call the parties in for a conference even before there's been a motion. But for the most part, motions are my introduction to the case.
And so in terms of factual development, these are things that are really important to do if you're doing a document review initially, is having some sort of a document review protocol worked out. Make sure the client understands the protocols that you're engaging in for reviewing documents, understand issues like privilege redactions, and work with the other side and negotiate the terms of the production. And then sometimes, and we do this a lot now, we use enhanced computer review processes to sort of figure out, well, let's figure out where the big important documents are, because again, you're always trying to figure out early on in a case, do I have a good case, a bad case? If it's a bad case, I better settle it quickly. And the only way to really do that is to sort of game out what is the evidence that's in the case and doing that document review quickly. It's also important to talk to your clients and figure out, what are the underlying facts. Now, if you're representing a corporation and you are interviewing a client or one of the employees of the corporation, it's really important to give something called an upjohn warning. And an upjohn warning basically tells the person who's being interviewed that you don't represent them, you represent the company, and that what they say to you can be disclosed, for example, to the government, and it's not privileged, and that to the extent that the client determines that the privilege should be waived and they want to disclose that information, because the client controls the privilege. And it's also important to be careful doing an interview that you don't coach witnesses. You want to get the facts. You want to know what the truth is, because it's much better to know the bad facts at the beginning of a case than to learn them, if you get to a trial or during depositions. Let's talk a little bit about settlement, which is really, Justice Schecter, what percentage of cases that are in your court do you think settle?
Probably like 98% of the cases.
And so you're always thinking, and I think I am as a lawyer, I'm always thinking about, like, how can I set up the settlement in a way that it will go best for my client? And so what are some of the things that in the commercial division you all do to encourage early settlement of cases? Again, trying to get to the expeditious resolution of business disputes.
So first of all, settlement is on our minds at every single appearance you make. So keep that in mind. You may be coming in for oral argument on a motion, but I'm always going to be asking, when can the case settle? Because my goal is the earliest possible time. Now, that doesn't always mean in every case it's right after the summons and complaint, although some cases that is the appropriate time. Sometimes, like I said, there's no transparency in terms of a dispute. So the court will get involved to ensure that certain core documents are exchanged, or we'll try to make sure you have everything you need to get into a posture. If it's discovery about certain damages, even if we just fast track that, because again, our goal is efficiency for you and to minimize the costs.
Now, sometimes parties will pick a mediator to resolve a case, and they'll, pay the mediator money. And sometimes, Your Honor, I guess there's a very experienced group of mediators in the commercial division who can help parties resolve cases. Could you tell us a little bit about that?
So yes, we have a mediation program in the courthouse that's here to help resolve. You tell them what the nature of your case is, and you'll get assigned someone. I will tell you that predominantly my cases do go to private mediation. And often that's because parties agree on appointment of a mediator, someone to settle the case, which is always great from a judge's perspective, because we have both parties buying in to use of a certain individual or an organization and doing that fast track. And they may have special expertise in the area too that all parties have confidence in.
Do you ever get involved yourself in settlement discussions?
Absolutely. I just spent my morning settling the case, in fact. But yes, there are times where I may be in the best position to settle a case, but there are other times where, like, for example, in construction industry, there are very specific details that I may not know as well as someone who's in the industry or comes from the industry. But in situations where parties are, it's very emotional, or sometimes even lawyers know that their clients aren't listening well to them. And that's when it may help to hear it directly from a judge. So particularly in cases involving a jury trial, where I'm not ultimately going to be the finder of fact, I have a little more latitude in terms of working on settlement.
What are some of the things you've learned that you've learned in order to try to get parties to settle cases? What are some of the sort of tricks of the trade?
Listen well. Listen very well to everything that the parties are saying. And I mentioned earlier, know their objectives, because you often can find a meeting point if you're listening well, and give and take if you know what the other side is willing to give. And it may not be something, or let's say it's something they're insistent on. The other side may not care about that particular point. So it's finding what's important to each of the parties and trying to broker an arrangement that's suitable enough for them.
You know, one of the things I've learned from being involved in the settlements of a lot of cases, sometimes the parties seem like they're so divergent in their views. And one party will say they want X bazillion dollars, and the other party will say, I'm not paying you anything. And then suddenly there's that moment where there's a break, and then suddenly there's an attempt to get a middle ground. How often do you see that happening in cases where the initial demands and the positions are so extreme? And how do you get the people closer together to actually get it resolved?
Very often, sadly, it's motions, as in that's what tells them, you think you're going to get, millions of dollars in punitive damages? You cannot recover punitive damages in this case. And once they have an appreciation of that, well, that's not available, suddenly they're becoming much more reasonable. There's also a lot of pain involved in the process sometimes. So people who are very insistent see the costs of the litigation. That's what I mean in terms of pain, the time, the cost, even though we try to minimize that. If you're not open to settlement, that's the trajectory of the case. And there does come a point where parties begin to see, I don't want uncertainty anymore. And, just even because you have a trial decision, by the way, doesn't even mean the case is over, because there are issues with recovering a judgment and judgment enforcement, and there are appeals. And once parties see the cost, sometimes if they don't appreciate it, they do cost benefit analysis, and it puts them in a better position, in more receptive to settlement.
Let's talk about TROs and preliminary injunctions. If you have a situation where there's, the money is going to be dissipated, something needs to be done right away, you can seek a TRO. And that obviously depends on satisfying certain requirements, including showing probability of success on the merits, a risk of irreparable harm if the case is not stayed so you can resolve it, and then balancing the equities between the parties. Now, drafting out a motion for a preliminary injunction, you have to sort of explain what the facts of the case are, discuss why there's a reason for getting a preliminary injunction. Judge, when do you see parties being successful in seeking either TROs and/or preliminary injunctions?
So first of all, it's a heavy burden. It's an extraordinary remedy, because very often, it's one thing if you're just seeking to maintain the status quo and try to prevent someone from doing something, but sometimes people are trying to get affirmative relief, forcing somebody to do something. That's a mandatory injunction. It's even more difficult to get. But the point is you as the movement have a heavy burden. You've got to submit evidence, because if you don't have evidence in support of your motion that's very strong, you are not going to win that motion. And then you have to think about strategically, was it wise to make that motion? Because if you're doing it at the outset of the case, do you really want a judge saying at the outset of the case that your probability of success on the merits is low?
And the other thing about it is you can force a settlement if you actually can win or lose, whoever wins or loses the preliminary injunction, because it's a way to basically get realistic expectation setting done at the outset of the case. Let's talk a little bit about motions to dismiss, which occur now. Complaint gets filed, and then the typical motion is the first motion that gets filed is the motion to dismiss. And there are a number of bases for bringing a motion to dismiss. The case should not be litigated in a New York court. Really, there's a more convenient forum, often a non-US forum, lack of jurisdiction, and failure to state a claim, and then removal can be one other basis. Let's talk about motions to dismiss. Now, any party who's a defendant in a case, a plaintiff, if there's a counterclaim, a third party defendant can move to dismiss under CPLR 3211. Now, filing a motion to dismiss doesn't automatically stay discovery, although there are ways to try to stay discovery pending the court's ruling on a motion to dismiss. Judge, do you see that happening very often where discovery stays are granted at the outset? Because, for example, in federal securities cases, there is typically a discovery stay at the beginning pending the decision on the motion to dismiss under a law called the Private Securities Litigation Reform Act. In New York State Commercial Division, how often is it that parties are able to get a stay pending the court's ruling on a motion to dismiss?
It's very case dependent. And in my part, you can get a stay What will impact that is I will analyze the motion and look at the papers, listen to what the parties have to say. And if I think it's going to be successful, I'm not going to have you go forward with discovery. Similarly, you may have a multi-count complaint, and let's say fraud is one of the claims. It will make a big difference in terms of the scope of discovery, whether the fraud remains in the action or doesn't remain in the action in terms of how, expansive discovery is. That's another situation where I might stay discovery if I see the fraud claim is not likely to survive or have serious questions about it, because I don't want the parties to go through the cost.
And the objective, of course, is always to get that fast resolution of the case. Don't have parties waste money on discovery, and also send a signal, hey, one side's got a better case than the other, and maybe you ought to think about resolving this case. Now, an important provision under the CPLR is 3211A1, which in the normal motion to dismiss, you have to accept the allegations of the complaint is true. But if there's a breach of contract case, for example, you can bring in, if you're the defendant, the contract, and you can actually put it before the court and then ask the court to, at the outset of the case, interpret the contract. A lot of the cases that you see, Your Honor, are cases involving breaches of contract.
Yes, this is definitely one of the more popular prongs that's invoked in terms of a motion to dismiss, where the contract, it would have to utterly refute the plaintiff's claim. So it basically would have to contradict the recovery that they're seeking.
That's why drafting contracts is so important, and making sure you have the right lawyers drafting those contracts, taking out those ways around the contract. Now, bases for motions to dismiss, one of the big ones is lack of jurisdiction. And you can argue the case should be dismissed for lack of subject matter jurisdiction, although it's a rare motion to get granted. Another motion,
in federal court, it's much more common in terms of because it's a limited subject matter jurisdiction. In state court, we have general. So that's why there's a big difference.
And one of the things you sometimes see is a motion for lack of personal jurisdiction, that the party should not be in New York State court. Maybe the case should be litigated in California or Texas or Florida. How often do you see motions for dismissal based on personal jurisdiction? And what are some of the bases for such motions?
I see the motions, and it's whether or not there's, for example, sufficient contacts with the state, and you have to look at the jurisdictional statute in terms of, what is the basis, not general jurisdiction, but the specific jurisdiction nexus. Connection to New York. Now, keep in mind too, many of the cases we see here have forum selection clauses and consent to jurisdiction provisions in the agreements themselves. So that would be the reason that we see this less often than you might expect.
One of my favorite motions is a motion for forum nonconvenience. That's probably because Sullivan Cromwell would represent a lot of non-US companies. And oftentimes there are disputes that are really foreign, that really don't have any connection to New York, or that really, there's a dispute between two foreign corporations, or the headquarters of the defendant is located in Europe or in Asia or in Latin America. And, you could litigate the case outside the United States. There's going to be a lot of hardship in litigating it in New York. The documents and the witnesses are all located outside of New York. The transaction was entered into outside of New York, and the litigation of the case will burden New York courts. And so those are types of cases where, while theoretically the New York courts would have jurisdiction, you have the discretion, Your Honor, to dismiss it on the basis of forum nonconvenience. When might you typically, do it in an obvious case?
When both parties are not New York residents or have no New York connections, when the transaction didn't take place in New York, and of course, most importantly, there can't be a New York forum selection clause. If there is a New York forum selection clause, that ends the inquiry. I will never dismiss for forum nonconvenience where the parties have agreed, even though neither party is from New York. If they've contractually agreed to have the case heard in New York, that's their agreement, and I'm holding them to it.
Now, the big motion that you often see, these 3211 motions for failure to state a claim. And those are motions where you have to accept the allegations of the complaint as true. You have to interpret them in the light most favorable to the plaintiff. And really the question, Your Honor, is determining whether the allegations state a legal claim. What are some of the do's and don'ts in terms of making a motion for failure to state a claim?
So again, the key thing is we're watching out for, does the plaintiff have a claim? It's not about like the exact words that they use. It's, do they, if I take all their allegations as true, have a claim? And that's why it's a very tough motion to win unless there's a hole. And keep in mind that you can, in opposition to a motion to dismiss for failure to state a claim, submit affidavits that show why there is a claim in opposition to the motion. And also, very often, parties will amend the complaint after there is a motion to dismiss based on 3211A7 to try to cure the defect. And there is an amendment as a matter of right before there has been an answer. You get one shot as an amendment as of right. So sometimes, even if you have a great motion to dismiss for failure to state a cause of action, the plaintiff can cure the issue.
Next up, certain types of claims, such as defamation claim, you've got to make the allegations in a fraud claim with some particularized facts, not just say, oh, the other side committed fraud or the other side defamed me. Other grounds for motions to dismiss would be there's an arbitration provision, or there's already been an arbitration award, or collateral estoppel applies. There's been a discharge in bankruptcy, res judicata, the statute of limitations applies, or it's a claim that really should be committed to writing and wasn't, and the statute of frauds applies. Let's talk a little bit, Your Honor, about writing briefs. What are some of the do's and don'ts that you see in terms of writing briefs?
The most important thing is put your best arguments up front, your strongest arguments, because you want to show, what the strongest ground is, and maybe the judge doesn't even have to go further in terms of convincing. What's your most airtight argument? Be sure to include that up front. Also be sure to state the grounds that you're seeking dismissal on, because 3211, if you look at it, it has very specific grounds. We've just gone through them. Make sure that the grounds you're seeking relief on are included in that section. Use precedent that's binding on the court in front of you. So in Manhattan, that would be the first department. If you're in Brooklyn, it would be the second department. But try to get controlling cases that are similar to your cases in terms of the language in the complaint, and draw on those. And also be mindful, like, what makes the most sense. Credibility is key. And this is a point that I may make. It applies throughout motion practice throughout your career.
Not too many adverbs and adjectives.
Not too many adverbs and adjectives, but also like losing arguments. Like if it's not a winning argument, don't think just because you're taking up space in the brief that you're doing your client a service. It's to the contrary. I'd rather have it be short and accurate and strong than just including like different alternatives when you really don't believe in the argument. It's not going to work in terms of failure to state a claim where plaintiff gets every favorable inference, or you say my documentary evidence is an affidavit submitted by my client. Clearly that's not the kind of documentary evidence that you can seek dismissal on. You can't manufacture an affidavit is something that a party says. It's evidentiary. It's their position. It can be factually challenged. It's not documentary evidence. Don't try to convince a judge otherwise.
That's why it's so important, though, Your Honor, to maintain your credibility when you're writing a brief. I hate to read briefs where people attack the other side in ad hominem or unfair way, or where people, miscite cases, or where they're not careful in using precise language. It's so important to maintain your credibility, because if you read a brief, I would imagine, and you see someone's miscited a case, or they using a lot of attacks on the other side, and they're not sort of just dealing with this in a professional in a professional way, they lose credibility, and you're more likely, I would imagine, to rule against them.
Yeah, it's noise. I mean, it makes me believe that they don't have good arguments if the best thing they're doing is just taking pot shots at the other side.
And I think it's also important to tell a good story and explain why the equities are with your side versus the other side. Let's talk about oral argument, which is one of the most fun things that a lawyer gets to do. And tell us about oral argument in the commercial division and some of the things that you think that lawyers should know when they argue before you.
Preparation is key. And part of preparation is knowing your judge. It can make all the difference in the world in terms of argument. And the interesting thing is post-COVID, many of us are doing virtual oral arguments, which means that you can watch your judge preside over oral arguments before you get up there and do it in front of that judge. There's no reason not to take advantage of that. Yes, you can ask your colleagues too, and that's great information, but watch, because some judges ask tons of questions. I'm one of them. You may not be able to get a word out, or some judges let you, I try to let you get a word out, but some judges haven't read the papers before you come in for argument, and you're giving them the introduction to the case. So it's very, very important to know the judge's style, because that will affect how you prepare. And what you want to do, of course, is, prepare in advance, do a moot, but taking into account the judge's style. Slides can be very effective sometimes, but I think if you're going to use slides, if your judge is one who reads the papers in advance, like I do, by the time you're getting to show your slides, I've read your papers, I've read the cases, and I have a very good idea of how I'm going to rule. And often I have oral argument to put my decision on the record after I've read the papers. So if you do slides, you might want to give them to the judge in advance, because that's when it would be helpful. For me, the slides come in handy if I reserve decision on a motion, but if I'm coming in well read, they may be superfluous at that point. But answer the judge's question. I can't emphasize that enough. Just like a witness at trial, if you don't answer the question that's asked, it makes us think either you haven't prepared or you're afraid to give the answer. That's even more what we're thinking, that you're holding back because you know that that's a big problem for your case. So what do you do if you have a big problem in your case? Address the issue. If there's a weakness and the judge is asking you about it, fess up to it. First of all, that will increase your credibility, because often the judge knows the answer. Sometimes the judge knows the answer to the question, but wants to hear you say it, or wants to see you minimize or what the impact of that weakness is. So know your weakness. If there's a case that goes against you, be able to distinguish it, be able to pivot into why it doesn't matter, minimize something that's bad, and then get back into your argument. What if you're asked something you don't know? It happens. Much better to acknowledge that you need to look into it. You're not sure, but don't fake it. I've had plenty of situations where lawyers make a statement in argument and they then have to officially retract it. And like I just said, credibility is key. That's not the way you want to go.
One of the most important things from the advocate standpoint is to do a moot and prepare and have your colleagues pepper you with questions so you're able to give quick and short answers back and you understand the weaknesses in your case. Another thing that I think it's really important is not to read your argument. I mean, how often, Your Honor, you see some lawyer will read their argument and it's basically just reading their brief and they're not engaged in a conversation with the court. It's so important. Oral argument is your one opportunity to get before the judge. And sometimes the judge may have a misapprehension about the case, not be aware of an important case, not be aware of a fact, not be aware of something that really is critical to the decision. And oral argument is a great opportunity to engage in a conversation. And all too often I see lawyers will get up there and just go into motor mouth mode, read a script, and they're not paying attention and listening to the court.
Yeah, and step up. Ask for the responsibility to do oral argument. There are many judges now who have rules that encourage participation of attorneys who are new attorneys. We want you to get your feet wet. So if you see those rules, like highlight it for the partner, because I'm more inclined to grant argument when I know it would give someone an opportunity to get up on her or his feet.
Let's talk a little bit about discovery motions quickly because we're running out of time. Discovery motions are often brought in the commercial division. You obviously are a court where you're focused on efficient resolution of disputes. Discovery disputes, in my experience, courts don't like to litigate them. They expect the parties to resolve things, amongst themselves. And when they don't, and they drag their discovery dispute, someone misbehaved in a deposition or want documents that are excessive, and they come to you. It's got to be kind of a little bit of an annoyance for you, and you really expect professionals to work out their discovery disputes. Isn't that right?
Absolutely. Meet and confer, avoid discovery motions. I have a rule that says you cannot make them without court permission. That's because I have confidence that you can work most of them out. A complicated privilege motion is the exception to the rule, but definitely have a conference with the court and the judge's rules.
Another area that sometimes comes up is expert discovery, and whether the expert, and under New York court, this is in the federal court, it's Daubert motions. In New York, they're Fry motions, and making sure that the expert is not a quack expert, but someone who's coming up with their expert testimony based on generally accepted scientific methodologies. Let's talk a little bit about, discovery. Sometimes you'll have situations where people will want sanctions. You sometimes get those motions, I would imagine, Your Honor. And it's got to be, I would imagine, fairly bad misconduct that's going to cause you to grant a discovery sanctions motion.
If you're hiding documents, you're likely going to get caught in this day and age with ESI, electronically stored information. So be forthcoming because you can really hurt your case if you don't. But on the subject of sanctions, I just want to throw out there too, remind everyone that we have a Rule 130 in New York, which is, it basically allows a court in its discretion to sanction parties for frivolous conduct. I don't think it would, we have to mention this in the context of motions, because if you take a position in a motion that's completely without legal merit, or misrepresent material facts, or take actions to delay or harass or prolong litigation, you can be sanctioned. And what I would say is this: if you're a party who thinks that the other side is doing something that's sanctionable, making a frivolous motion, warn them first. It creates a good record for the trial judge in terms of taking it seriously, and it allows the other side to withdraw their motion before you have to respond to it in the first instance.
Let's talk about summary judgment motions. And a summary judgment motion comes typically after discovery has been taken and before trial. And it's really to determine whether there's a material fact in dispute that warrants having a jury trial. And the way it works in New York court is the movement has to make a prima facie showing that there's no issue of material fact in dispute. Then the burden shifts to the other side, and then the courts have to view the evidence in the light most favorable to the non-moving party. And then there's an obligation in connection with a summary judgment motion to have a statement of the various material facts that the party who is the movement thinks are not in dispute, and there's no issue to be tried. And then the other side will come up with a corresponding statement and identify all the points in the record of where there's a material fact in dispute. And you have to, it's very important to include a citation to the record so that the court can identify the material facts that are in dispute. Your Honor, what are some tips for drafting summary judgment motions?
So one very important thing, read the judge's individual rules, because again, some judges don't require, some judges, like me, prohibit the competing statements of material fact. So I've had people submit motions for summary judgment with that statement and then say, we win because the other side didn't oppose, but my rules say don't do it. So you're wasting your time if you don't read the judge's rules. It's very important. Also think hard about whether or not your case is appropriate for summary judgment. The burden shifting, a lack of proof from the other side is not going to get you summary judgment. You have to affirmatively show as a matter of law that there's no dispute of fact and you're entitled to summary judgment. You can't point to gaps in the other party's evidence. So focus on that burden shifting very much, and also think about what the likelihood of success is. These motions are very expensive. If there is an issue of material fact, the judge will probably see it right away. So think twice about making that motion.
I always think that in a summary judgment motion, it's important to tell your story in a way that is compelling and that shows that the equities fall on your side of the ledger, and keep things simple. I find that sometimes lawyers will want to make overly broad motions and not focus on the key issues that really can decide the case. What percentage, Your Honor, of the cases that are in your court would be resolved on a summary judgment motion, roughly?
You know, what percentage of cases? I don't know.
Maybe. Well, probably then would get settled, get resolved through trials, though, wouldn't you think?
Trials or settlement, you know, by that point, they're ripe for settlement once they've exchanged, they've gone through discovery. But, you know, many summary judgment motions are successful because not every case has a summary judgment motion. And parties really do think about, and, you know, again, my clerks are excellent and they're very good at when they are prepping and they're setting the schedule. You know, they'll tell you, well, I don't know how successful this is going to be in light of these competing facts. And attorneys will take it to heart and speak to their clients and say, look, you know, this really may not be a successful motion for summary judgment. We don't want to waste our money. So case management is also a good key in terms of summary judgment. But put your evidence, cite it, and yes, please keep it very simple and easy, and you know, tell a great story, keep our attention, but show us clearly why there isn't a dispute on material facts, like something that's inconsequential won't matter. You know, highlight why you are entitled to this relief. And it's a heavy burden.
One point that I think it's important for people to keep in mind, that on a motion to dismiss, you're really stuck with the allegations of the complaint. But a summary judgment motion is a motion that's made after discovery, after the depositions have been taken, after all the documents have been exchanged, and you can really cite the entire record and really establish whether there's really a need for a trial or not. And again, like everything else we've been talking about, at every step of the way, the lawyer has to be thinking, what's in my client's best interest, and is there a way to resolve this case without spending, you know, more time and money on the case? And I found that clients, if you can resolve the case fast and efficiently, will come back again with more work. And they don't really like the lawyers who drag the cases out when it's inevitable it's going to settle, and you could have settled the case at the beginning. Let's talk a little bit about appeals, and then I think we'll have a little sum up and then wish everybody a great afternoon. Appeals in New York State court are a little different than in federal court. In federal court, you need a final judgment. And really, you can't appeal a motion to dismiss. You can't appeal a summary judgment motion. You can't appeal injunctions when they get granted. But in state court, you can make a motion. You can appeal a motion to dismiss, the denial of a motion to dismiss. You can appeal the grant, obviously, of a motion to dismiss. You can appeal the denial of a summary judgment motion. And that ability to bring those appeals is important, because that becomes, you can sort of go to another decision maker and get your case resolved. And parties are always looking to figure out, well, what does the judge think? And I think appeals do add sort of in state court, add another option, another venue to have your case be decided. What do you think, Judge?
It's a big difference between state and federal court. And, you know, again, it certainly is a factor in why people decide to go to the commercial division or seek removal.
And again, you know, a couple of issues. Sometimes you can, the thing, keep in mind, one of the problems with that accelerated adjudication we talked about is you don't have the ability to bring these interlocutory appeals. So we've been talking for about an hour, and it's time to get everybody, you know, back to work, or to the social event of the afternoon for the summers. What are some of the do's and don'ts of motion practice, Your Honor, that, you know, after years of being in the commercial division, are the ones you'd want to leave as a closing comment to the lawyers?
So preparation is key in terms of oral argument, have a strong command. And again, whether it's in writing or whether it's orally, communicate well, tell a story, be a person, evoke, like show what's important about your case and why it stands out. Don't be rehearsed. Don't put dispassionate. I mean, when I say dispassionate, I don't mean you should, invoke and insightful things and, like be inflammatory. But what I'm saying is make it interesting and clear and short and to the point. And if you do that, it will have much more impact than if you're flailing and have lots of different arguments that are not as good as the ones that you really put the time into.
Yeah, I guess mine would be definitely read the judge's rules, listen when you're in doing oral argument and answer the questions. And I think my big ones are, again, at the beginning of the case, figure out, sort of game the case out. The best lawyers are the strategists, the ones who they see a dispute and they sort of can see the future and understand, well, this is how the judge is likely to rule on the motion to dismiss, summary judgment motion. Will it ever get to a trial? You're always thinking about what's the settlement value of the case. How can I resolve it for my client in the best way? And again, I think it's important, Your Honor said this multiple times, keep it simple. There's so many, oftentimes people, I think Abraham Lincoln said, you didn't have time to write a 2-page letter, so you wrote a 5-page letter. Less is more. Figure out what really will, it's advocacy. And the best advocacy is simple advocacy, not complicated advocacy. Judge, you get the last word. Any other thoughts?
No, I just wish you all tremendous luck. It's such a great profession and you have the ability to do so much good. So I hope you enjoy your careers as much as I've enjoyed mine.
And thank you so much, Your Honor, for participating. I've really enjoyed it. And if anyone, has any questions, you can get me on my email, which is my last name with the letter R @selcrom.com. And I really wish everyone a great summer. And hopefully the skies will clear up over the rest of among the rest of the country. I'm in Washington today, and it's not so good here. I thought it would be better. It's further from Canada, but it hasn't gotten better. So thank you all so much, and have a great day.
Mr. Giuffra, Justice Schecter, thank you so much. And I want to remind the students that we have a program on June 13th on depositions, June 20th on written and electronic discovery, and June 27th on trials. So enjoy your summer, and thank you both for getting us all the way through appeals. Thank you.
Have a great summer, everyone.
Great summer, everyone. Bye.